Nomalanga is a senior lecturer in cyber law at the University of Witwatersrand, and someone still isn't muted. So could you please mute yourself, because we want to make sure that everybody, thank you, everybody can listen in on this wonderful talk by her. She's a lawyer by training. And now, of course, working academically, her research focus is on the protection of image rights around the globe. She explores the interplay and conflict between artificial intelligence and social media regulation, and their influence on the misappropriation, falsification, and commercial exploitation of individuals' identities. And Nomalanga is also the host of a podcast. I just learned it's starting season 5, I believe. It's called Image Rights by Mashinini. And it's the only podcast in the world with a sole focus on this topic of image rights. I asked her to also share with us a link, possibly in the chat, either now or later. Nomalanga will speak for about 30 minutes. It would be great because students usually leave for classes shortly, like maybe 10 to 1. So right now it's 12 for us. And so it would be great if you could keep the 30 minutes limit, or even go shorter, so that we have ample time for questions. As always, if you have technical difficulties, feel free to raise your question in the chat so that I can read it. And we don't allow any AI tools for this format. Thank you for your understanding. And without further ado, Nomalanga, the floor is yours.
Thank you so much for that kind introduction. I'm giggling because I was busy trying to put the link in the chat, and then you called me to the stage. So I've shared it now. I'm sure there'll be some interesting things to explore there. So I have expertise based on my doctoral thesis on image rights. I believe in other parts of the world, image rights are often referred to as the right to publicity, or right of publicity in the United States of America, and in some European nations, you find that it's broadly termed along the lines of personality rights. And in South African law, we refer to it as the right to identity. And so when I was invited to do this talk, and I'm very grateful for this invitation, I thought to myself, do I go for a show and tell type of presentation in terms of synthetic media and how this is manifesting this commercial exploitation of identity through AI and social media? Or should I simply get into the more theoretical issues relating to regulation, as well as the intersection of social media governance, really around people's likenesses, people's identities, and how AI and social media work together to enable or facilitate the commercial exploitation, sometimes unlawfully, of people's identities. And so I chose the more theoretically grounded approach, because I could sit here all day and show you videos of memes that have motion and deep fakes and the like, but I think maybe I should share my insights on things that I've uncovered across various jurisdictions on this topic. And so this topic is work that is based on my doctoral studies and postdoctoral research as well, and also something that I'm moving towards in terms of a research project. So by way of overview, I would like to just give a brief description of how this conversation will go. I will begin by basically introducing this image-based economy issue, around why it's so important to understand why your image is quite valuable in today's economy. And also, I'll touch briefly on what I call the identity exploitation life cycle and why that is key to this conversation. I will also discuss the dual nature of identity protection and exploitation, and why it's important for protection with a comparative snapshot of jurisdictions like my country, South Africa, the United Kingdom, particularly English law, as well as two selected states, California and New York, in the United States of America, since those are celebrity states. And also, I will talk a little bit about what we mean or should mean when referring to commercial exploitation and commercial gain of people's identities or people's likeness. And then I will show how my newly established research group or lab deals with the particular problems that I've identified and what our contribution is here through the WITS image rights engagement, fondly calling it WIRE. So it is quite an important thing to grasp that one is living in a very image-centric universe or world. In fact, I want to take it back all the way to what I would believe is the beginning, given my Christian roots, because it is in Genesis chapter 1, verse 26, where, according to the Bible, God was speaking to the heavenly beings and he said, "Let us make man in our image, after our likeness, and let them have dominion over the fish in the sea, the birds in the sky, and every creeping and crawling thing." And so there is this idea rooted in those religious and sometimes also philosophical principles that the image that you hold is important, and that it's made up not only of your face, but also of your likeness, the way you speak, your voice, your name, your signature. And law has found or founded recognition for these personality interests in your image. And hence, I often refer to this as image rights, because the term image is much more broad enough to cover the full aspects of what you are made up of as a person in terms of what we see, what we hear, and how we experience you. But now in this image-based economy, your image is very valuable. In fact, if you bring it together with the social media context and the AI-driven world where we now deal with generative AI and how it basically affects or influences how we interact on social media through sharing of memes and deepfakes and the like, you realize that, well, it seems that one's image becomes a sort of like a multiple data points issue and an asset rather, and that can be leveraged across different sectors for social, economic, as well as technological power. And the reason why I mention this is because there are multiple sectors and issues that arise in relation to how your image is used on social media and how it's processed through AI models for training and exploitation. And I will list 7, but there's a lot more that I could go for. The first one is elections and democratic governance. We've seen one of the first problems that came up back in 2017 when deepfakes became a serious problem was election manipulation. And Texas in the US was one of the first few states to try and address through regulation the issue of using likeness to manipulate elections, especially with deepfakes that are very the most deceptive form of synthetic media. And then we have security, policing, and cybercrime issues that come up. This is where you're talking about interception of data, manipulation of data, fraud, uttering, forgery. And number 3 would be the sector relating to advertising, brand marketing, and now influencers as well, where you see this leveraging of image or identity for social, economic, and technological power. And then you also see it mostly, like we've experienced in South African context, financial markets and consumer manipulation, particularly where deepfakes are used by criminals to defraud people and make it seem as if they are worthy investments for them to invest in by using a celebrity's or trusted person's face to attract these consumers, to buy products sometimes that don't even exist or products that are not approved. You also see it in humanitarian response and conflict monitoring, and of course, the likelihood of wars starting because of synthetic media that has been created at the exploitation of someone's identity or image to trigger some sort of conflict. And you also see it with child protection and online safety issues. Child sexual abuse material in particular is on the rise on the dark web, and sometimes even on platforms owned by Meta. We recently experienced that in South Africa, where Meta was allowing anonymous users to post child sexual abuse material, some of it real, some of it fake, but it was going on for some time until legal action was taken. And last but not least, one of the most important sectors is obviously the creative industries, where you have cross-sectional issues around intellectual property, particularly copyright and the like. And so it tells us something important, and why I say your image is valuable is that an image or an ordinary image is no longer just about protecting your privacy or a sense of vanity or a sense of the individual being at the center of it, but rather it is, we see now that image or likeness is now infrastructure for politics, security, markets, humanitarian work, children's rights, and intellectual property all at once. And so that gives you sort of a broad picture of just how important the image has become in this image-based economy due to how social media and AI operate together, oftentimes together, through users who exploit commercially or otherwise people's identities. And this exploitation happens through a particular life cycle where obviously there is the initial stage where either you take a selfie and post it, or someone captures an image of you and it ends up on the internet, particularly social media platforms. Because remember, back in the early 2000s, when social media started to boom, especially when Facebook started to boom, the focus, and Mark Zuckerberg emphasized with Facebook in particular, that it is about networking and being social with each other and sharing of experiences, reconnecting. And so people got into the habit of posting their information online freely, and that information ranges between images, literature, content, voice, video, and the like. And thus this created a sort of datafication kind of environment where all of a sudden all of this data was being uploaded so freely and so willingly by us on social media platforms. And it is no wonder why social media platforms like Meta have, or social media businesses like Meta are becoming AI companies, and AI companies such as OpenAI are sort of becoming social media companies, because in order for you to obviously do AI model training and deal with proper input training, you need data, and that data now is us. It's our image, it's our likeness. And we end up with this life cycle where it's from the image capture to the social media platform, creating data for AI model training, which helps to produce the synthetic reuse of one's likeness, be it in a meme, a deep fake, advertisements, etc. And this is where harm often happens. Although if you look at the life cycle, you'll realize sometimes harm can start much earlier. Because, for instance, sometimes it happens that at the image capture point at the beginning, it may not even be consensual, that image capture, and then it runs through the pipeline of social media platform upload. It becomes data for AI model training and becomes output at a later stage. Whether it is altered output or the same type of output, it nonetheless becomes output for synthetic reuse. And the kinds of harm we often see here, for instance, we see cybercrimes such as fraud, forgery, uttering unlawful access to people's images or likeness, interception and interference with their data, and all of these tend to happen at the different stages of this life cycle. So it is important then to understand that then when you think about identity protection or image rights protection, there are two parts to it. The first part, we look at what image rights protection is rooted in, which is the control over one's persona in public. So how is your persona or your personality experience published and shared in public, be it online or not? And so there's a privacy element, and historically you'll see even in the jurisdictions I'm going to discuss on the next slide, there's a privacy element at the core of identity protection, which sometimes creates friction between protection mechanisms that we use for identity or commercial exploitation of identity, right? Because you're dealing with invasion and disclosure that may or may not be unauthorized or justifiable in law. The second part, you're dealing with the more sort of commercial aspect of this protection and exploitation, where we're looking to the commercial use in advertisements, for instance, of a person's identity, because in different jurisdictions, law recognizes, legal principles recognize that one cannot use without permission another's identity for commercial benefit. But these aspects of identity protection or image rights protection are challenged in today's social media and AI image-based economy. Now, I want to give this comparative snapshot of image rights to show that there is some fragmented protection across jurisdictions, but due to limited time, I'm only going to speak of it in the context of South Africa, English law, particularly in the UK, the US. I'm going to look at New York and California. But there's a lot more other jurisdictions that I could pick up on, even in Africa, for instance, Kenya, Uganda, Nigeria, who have similar rules to South Africa. But for this purpose, I really just want to give a much more cross-regional type of perspective of what do we see in the form of protection here. And I'm going to spend quite some time on this particular aspect. So in the first instance, in South African law, what we find is because we have Roman Dutch law and colonial historical legal roots, we see how under Roman Dutch law, common law development, our courts have typically protected people's identities against commercial exploitation, falsification, through injury to personality claims. So this is tort or delict in our context. And we see this examples of it also manifesting in the development of these injury to personality claims, in tort claims for compensation, sometimes interdicts and the like, developing into privacy claims and the right to identity claims. And the main right that we see today in the South African context is referred to as the right to identity, where it protects one's likeness from commercial exploitation, misappropriation, and falsification. We've seen this, these examples or endorsement by courts in the context of using in a business, for example, without their permission, riding on their name for that purpose, to advertise or to gain some sort of customer base using someone's name. We've also seen it with cases where, for example, in Kumalo versus Cycle Lab, you have a celebrity whose image was used in an advertisement flyer. We've also seen it in instances where various legislation has come to the fore to attempt to deal with more specific types of image exploitation. In Cyber Crimes Act, we've got image-based sexual abuse protection under malicious communications in Section 16 of our Cyber Crimes Act. We've also got films and publications regulation that deals with the exploitation of people's identities through AI tools such as deepfakes, for instance. And we see it also in data protection legislation in the form of the Protection of Personal Information Act in our country, which is very much comparable to the GDPR. But in instances such as the UK law, for example, what we find is, firstly, oftentimes there's a distinction between how those who have some level of goodwill to their name, typically celebrities or public figures, would often go for a passing of claim, as we saw with the Rihanna case in Fenty versus Topshop. But the more private persons would use or go for a claim for misuse of private information, which is basically a codified type of tort claim that would yield compensation or takedown and the like. And in the two cases that I've put up there in Murray and Willer, you had celebrity cases, but the claims were for their children who are not public figures, and which is why they would go for the misuse of private information instead of passing off where their children's images were published in tabloids and newspapers and magazines. And these cases in both South African and UK law basically give us the foundational principles that allow us to vindicate the exploitation, commercial exploitation of identities even today in the social media and AI context. So we've got that rooting or that foundational aspect that we can look to. But in the UK, the courts have been very clear that they do not recognize what is known as image rights, and thus it remains deeply rooted in privacy protection. And I'm going to explain why this is a problem in a short while. In the United States of America, you have what they call the right of publicity, although it is not recognized as a federal right of publicity. And the substance of it really in different states remains similar to what we have in the South African context, deeply rooted in privacy invasion tort for unauthorized commercial use of likeness. But there are aspects of it that have been codified in different legislation in different states. And I chose the two examples of New York and California here because these are the states that were quite early in developing legal rules to deal with these issues, because obviously you've got a lot of public figures living in these particular states who have experienced instances where their images have been used in video games, for example, particularly their football players. In the Keller case, for example, a football player's image was used in a video game without their permission, and that was found to be commercial use of likeness. But what is also quite interesting with the US, which is different from South Africa and UK, is in South Africa, you find the protection of the right to identity being one that relates to a living person, but it ends when the person passes away. The same thing with the UK context through the privacy element, that these are personality rights that end at a person's death. But in the US, in these particular two states, New York and California, we've got examples of, for example, in the New York Civil Rights Law, sections 50 and 51, it allows protection against the unlawful use of a person's name or portrait or picture, whether they are living or even in the post-mortem context, so after their death. And it provides these remedies to the benefit of the particular person's likeness to be protected for an additional 40 years after they have passed away. The same thing with California, where they've got the California Civil Code under Section 3344, which provides liability for damages for a person who uses, your name, your voice, your signature, your photograph, your likeness without any prior written consent on merchandise and goods and services. And California stretches a little bit further than New York by enabling these rights to subsist post-mortem for an additional 70 years after a person's death. And this is quite key because even in data protection conversations now and debates, we are having this question about should we look to protect certain personality interests such as privacy and publicity or image rights beyond a person's death? Because oftentimes when someone passes away, it is the time when they become very famous, their images become very popular for public use without consent of their family members. Nevertheless, in seeing the problem with the commercial exploitation of people's identities through AI and social media, recently Trump signed the Take It Down Act, which gives a bit of an image rights angle at federal law, but is not actually a protection of image rights or right of publicity at federal level. What it really tries to focus on mostly is non-consensual intimate images, including AI-generated digital forgeries or deepfakes, right? And it criminalizes knowingly publishing or threatening to publish intimate images without consent, and it imposes rules on social media platforms that they have to remove reported content and whatever other copies of that reported content within 48 hours of receiving a notice that this content violates certain rights or violates the Take It Down Act. And it relates to image rights in the sense that it recognizes some level of federal protection for intimate visual identity, including deepfake versions of identity. And it is quite a step forward, I would say, in the long-standing questions around why is it that US does not have a federal right of publicity? Because across the 50 states, you've got different approaches to regulating publicity, and some harmonization is needed there. But it's also important to look at the social media platform principles as well, because most of them, what you notice if you do a survey, is most of them normally deal with privacy issues mainly. There's a heavy focus on privacy, and it's quite understandable if you think about the fact that oftentimes these social media platforms will align with the legal principles that are founded in their own jurisdictions, because obviously if you're dealing with social media platforms that are developed and that are having their headquarters in the US, for instance, which is heavily focused on privacy invasion torts for right of publicity protection, their foundational principles and policies of Facebook, for instance, will begin with a focus on privacy as well. It will not jump straight into protection of likeness. And there's this tight relationship that I do not believe it will ever go away between protection of privacy and protection of identity or protection of likeness that you see is carried over into the social media platforms. If you, for example, look at other examples like TikTok and LinkedIn, you will see there is some level of deep fakes focus and likeness focus over the years. At the time when I was doing my PhD, deepfakes had already come to the fore because deepfakes first surfaced in 2017. But the social media platforms did not have any outright ban or prohibition or any policies on that at the time. Even around 2021, at the time, there wasn't anything specific. But now they have been updated, a lot of them, to deal with this dimension of social media and AI commercial exploitation of likeness. So some of the community guidelines and policies ban synthetic media that deals with AI-generated content. In fact, TikTok is quite strict on requiring this kind of thing to be disclosed as well. YouTube also requires disclosure, but is not so strict in enforcing non-disclosure of synthetic media use. And it allows, TikTok allows removal of this content if it is flagged, and it can even restrict violating accounts. LinkedIn, on the other hand, even back in 2020, LinkedIn already had a particular focus on likeness protection. And I believe it's because LinkedIn is a more professional platform, and people's reputations are highly guarded in that kind of community. And so the professional community policies obviously would want that your profile must reflect you instead of reflecting someone else's face. For example, you cannot be permitted to do catfishing on LinkedIn. And so likeness is really focused on authentic identity on LinkedIn, and it is more about proving that it is you who's there. Facebook now has a new dimension of focusing on likeness, but it heavily focused a lot on privacy in the past. And that gives you a bit of a broad overview of what you're dealing with. But
it would be great if you could come to a conclusion, Nomalanga, so that we still have time for questions.
All right. But I am drawing to the conclusion that a lot of these platforms and a lot of platform policies and a lot of legal rules do not actually focus on what do we mean by commercial exploitation or commercial gain. And even in courts, in the different jurisdictions, when there is a claim that is brought in, none of these courts really focus on what is the meaning of commercial exploitation or commercial gain. It is often assumed that if someone's identity is used, say, for example, in adverts and so forth, that there is commercial exploitation. However, on the social media dimension, if I'm not making money off of someone's image that I've used maybe in a deep fake, but I'm getting likes, follows, and attention, commercial exploitation should be reinterpreted for AI and social media, and it should not only cover monetary gain, because driving of likes, follows, reposts, and so forth, all those analytics that you get are a form of commercial benefit. And it should be understood as a form of consideration in this attention and data economy. And also, courts should recognize that in claims for image rights protection, that even in instances where there is no monetary evidence, because courts like numbers, even if there's no monetary evidence, the mere fact that you've got this form of exploitation, if harm can be proven, it should be found that there's a violation. And so this is where, in closing, I advocate for an economically, socially, and technologically advanced approach to image rights protection that would have the following pillars. That in developing remedies and solutions, we should base it on evidence and infrastructure that shows how AI and social media work together to commercially exploit people's identities in new ways or nuanced ways in this AI and social media driven world. And we should focus a lot more on policy development, mapping of new types of remedies, even technological remedies through law and policy, and of course, education, outreach, developing specialized clinics for this type of exploitation is important. And this is why, and I would like to invite you all to find out more about how our commitment at WIRE, for instance, is key to this kind of intervention for this advanced approach that engages knowledge production, technological innovation that combines regulation and policy development to effect structural change.